SJC-10503, Commonwealth versus Penn.
Thank you.
Good morning.
Good morning, Mr. Kern.
May it please the Court, Dana Curhan for Lewis Penn. I'd like to start off by addressing the sufficiency and weight of the evidence. In my brief, I actually address 2 points regarding sufficiency, and I also argue the weight of the evidence under 278-33E. The 2 points on sufficiency are the standard Lattimore standard, and then I also ask for a reasonable jury standard. But I think it's helpful just to look at the evidence, and whatever relief, if any, I'm entitled to, I will take whatever the court will give me on this. So let me start off with the evidence. The identity of Penn as the shooter was essential to a conviction in this case, and no witness specifically identified him as the shooter. We had a gentleman named Jose Estrella who saw the shooting and testified that he was about 300 feet away. It was a rainy night. It was dark. He said that the shooter was taller than the victim, and that is the evidence, the main evidence linking Penn to the shooting.
Well, you have that the victim was shot by a taller man. The defendant was not Serrano. This was brought out by eyewitness testimony and by the autopsy. That the defendant had a hood on, but Serrano did not. That was also brought out through an eyewitness. And the defendant fled and then gave a false account of the night of the shooting. And you're saying that doesn't add up to sufficient evidence?
I'm saying that doesn't.
Why?
And, why? Because I think none of that evidence is conclusive. There is evidence presented by the Commonwealth that I think would equally support a finding that it was Serrano rather than
the shorter
Penn.
man could have shot from the angle that the victim was killed by?
I think so. I mean, I state in my brief that Estrella acknowledged that the victim could have been crouching. Now, that's a little bit inaccurate.
The evidence that the victim was crouching?
Well, what he said is that he couldn't see. He said he was standing up straight, but he couldn't see from that distance whether he had his knees bent. And you know, it was. We're talking about a matter of a few inches from a distance of 300 feet.
But the question is sufficiency. Could a reasonable jury have drawn the inference that it was the defendant who was the shooter, since he was?
My suggestion is that is simply one factor, and that's not enough. There needs to be more.
But there was more. That it was not Serrano who was wearing the hood. The defendant was. That was also seen. There was
evidence that both of them.
And that the defendant fled, and that was consciousness of guilt, as was his false account of the night of the shooting.
There was evidence that both of them were wearing fairly similar clothing. One of the police officers who responded to the scene said that he got a report from another officer of a person whose clothing matched the description of the defendants who had fled the scene. He then stopped Serrano. He found him out of breath. He found that he was wearing wet clothing, and the descriptions of the clothing, I think both of them were fairly consistent.
Wasn't there eyewitness testimony that Serrano did not have the hood on at the time?
I think there was actually testimony that neither of them had a hood and that both of them had a hood.
But I thought there was testimony that at the time Serrano was not wearing a hood.
I'm not certain about that. I think both of them were wearing clothing that was consistent with the shooter, and again, one of the officers testified that he got a description of somebody matching the shooter, whose clothing matched the shooter, and he found Serrano. He stopped him, he questioned him, he let him go. When you look at the other evidence, again, presented, and this, in addition to going to the sufficiency of the evidence, this also goes to the weight of the evidence, which this court is entitled to take a look at. But when you at the fight earlier, just before they fled and the shooting took place, Serrano was the one with the gun, and what he did with the gun is he pulled it out and he put it on the top of the victim's head. And that's exactly what happened when the shooting took place. So I think that is consistent with our theory that it was Serrano rather than Penn that did the shooting. There was a medal found at the scene, a medallion, and that also belonged to Serrano. Again, that was not the scene of the fight. That was the scene of the shooting. And when you look at Stephanie Bertone, who described one of the incriminating statements that Penn made after the shooting, he said something to, I'll tell you exactly what he said. He said he had been with Benji driving around, and Benji had a gun in the car. Benji saw someone he didn't like, and they stopped. Benji argued and ended up fighting with the kid. Benji told him to get out of the car and bring the gun out. Penn walked over to Benji and handed him the gun. Penn told her, quote, "You can guess what happened." I think that statement is consistent with the fact that, yes, he did handle the gun, but it was Serrano who ended up with the gun. There's a statement to a local police officer in Pennsylvania where he said, he said he had the gun, which nobody disputes. He did have the gun at the scene of the fight, and things just got crazy. These are statements, there's obviously consciousness of guilt, and the consciousness of guilt is probably equally consistent with a theory that he was a mere participant but in the fight, but wasn't the shooter, as with the theory that he was the actual shooter.
Now, in this case, was there a joint venture instruction given?
There was not. My understanding is that Serrano was tried separately. I think he was tried on a joint venture theory. There was no joint venture theory. The instruction was, if he's the shooter, he's guilty. If he's not the shooter, you have to acquit him. So when you look at the totality of the evidence here, my suggestion is that it's not sufficient under the Lattimore standard. I asked for a more stringent standard.
Yeah, is there really a difference between any rational juror versus a reasonable jury?
I think there is, because I think you could look and say, well, if one juror could find guilt, then that's sufficient under the Lattimore standard. And rather than...
Because you're translating any reasonable trier of fact to mean any reasonable juror?
I think the rational jury standard, I think, requires just one juror. If any juror somewhere could find guilt.
Any reasonable juror somewhere.
Any rational juror. I think that's the standard.
Okay, is rational different from reasonable?
I think we're looking for, there's got to be a finding.
The Lattimore standard asks whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And I've always understood rational trier of fact to be the jury as a whole rather than any one juror.
Judge Newman from the Second Circuit wrote a very nice article, and it's been quoted a lot, and there's been some criticism of the any rational juror standard in that it may look at just one juror, or it may not. There may be a jury somewhere that would find guilt, but I think what we have to look at is, could a reasonable jury find guilt? And our contention is that it could not. And my alternative argument is under 278-33E, the evidence just wasn't sufficient, and the verdict was against the weight of the evidence, even if the verdict was legally sufficient. So I suggest that we're entitled to dismissal, but if we're not, we're entitled to maybe a new trial, maybe a reduction of the verdict, any relief that this court determines that we're entitled to.
And what do you make of the fact that I gather there was evidence that during the course of the fist fight, the defendant is pointing the gun right at the victim's head throughout the fight?
Yes, he is. He then hands it to...
Isn't that consistent with something more than him just being there to provide backup?
Well, I think that probably establishes his guilt in his involvement in the fight. What happened was everybody took off, and only one person followed the victim, and only one person shot him, and the evidence has to support that he was the shooter. And that's where I think the Commonwealth's case falls short. Now, kind of a somewhat related issue, we challenged the identification instruction provided by the trial judge. The trial counsel had asked for essentially the Rodriguez instruction supplemented by the possibility of an honest but mistaken identification instruction set forth in Commonwealth versus Presley. The judge said, I'm not going to give that. That gets into me getting involved in fact-finding. I'm not going to do that. There was an objection. I indicate this in my reply brief. The judge says your rights are saved. Thereafter,
but my understanding is he didn't give it because he said there really was no positive ID by Estrella. He didn't want the jury to understand from that Estrella had positively ID'd the defendant.
Well, that was part of the discussion of the Rodriguez charge, but I think the judge said, let me play with that, but I don't think that would have suggested that there was a positive identification. Nobody ever did suggest that. What the difficulty is that he made a statement that really was the crucial piece of evidence supporting the conviction, and the jury was not actually allowed to consider or not instructed to consider the possibility of an honest mistaken.
Well, you know, it's kind of troubling because after the instructions were given, he didn't call the omission to the judge's attention at all, and twice said he was satisfied with the instructions that were given. So it's kind of hard to see exactly how, in this continuing dialogue, that the objection to Presley, the non-giving of Presley, was preserved. Because he got the Rodriguez instruction he was looking for.
He asked for the Presley instruction in writing. There was a discussion, and the judge said, I'm not going to give it. But
he wasn't going to give Rodriguez then either, in the form that was wanted.
Well, I think he was going to give something.
He was going to give something, but he you know, was. I mean, I think that the discussion's kind of vague as to what it was, and then he came back and then he changed his mind, and then the defendant says he's satisfied.
I think he was going to give the modified Rodriguez, and that we don't have a problem with.
He didn't say he was going to give the modified Rodriguez, did he?
Well, I think there was a discussion that he was going to
take a look at it,
play with the language. But I think, and he ultimately came back and did give a modified Rodriguez.
And really it was the reliability, not the veracity of this guy's eyewitness testimony that was really in contention, right?
Right, but that's why this instruction goes to the reliability. It doesn't go to the veracity. The Commonwealth argued, you know, he came in and he told the truth. That's something that I'm going to leave that issue to the brief, but he came in and he told the truth. We don't really dispute that. What we dispute is that he may have made a mistake.
And but doesn't that go to the reliability? If he made a mistake, he made a mistake because it was dark, it was raining, it was distant, it was all those things. It wasn't. I'm having trouble seeing sort of what the problem here is. Well,
I mean, I think the Rodriguez instructions address those factors, but I think tying it all together and giving the jury permission to say, you know, this guy came in and made an honest mistake. I think that's what's important. This court decided Gomes and Johnson a few months ago, and one of the things in the, you know, obviously that's the model instruction that's now given is much different from what we have here. It talks about all the scientific evidence, but one thing that is actually incorporated in that model instruction is the Presley language. And, you know, we don't ask for the new language that this court articulated, but we asked for Presley, and I think that was important at the time. And it was certainly, he was certainly entitled to it at the time. I want to touch very briefly on the closed courtroom issue. I know that this court has handled at least a dozen cases on this point. The only thing I really want to say is that a cert petition has been filed in LaChance, and my understanding is that the Commonwealth has been asked to respond to that petition, which is not typical. It doesn't mean the petition will be allowed, but it at least means that the federal courts are taking a look at it. What I think the difficulty is that the federal courts have required a more substantial showing of a waiver than what this court has articulated. And also, the federal courts, my argument is that they presume prejudice where you have a structural error. So my suggestion is that this court has actually adopted a standard that's more stringent than what the federal courts have required, and I ask this court to take another look at that. The only other point...
I'm sorry, with regard to the issue of waiver, is it, I get confused with the cases, but is this the case in which the defense counsel told the family members you can come back in after the jury selection was over?
Exactly.
So he knew full well that they were outside and didn't bring it to the attention of the court.
Exactly, but my point is that I think the defendant never knew about this, and I asked the court to take another look at what you need for a waiver. Is it something that a lawyer can do? I mean, trial counsel's deceased, so we don't know what his thinking was. But the defendant certainly was never aware of this, and we asked that we suggest that maybe this is inconsistent with what the federal courts have been saying about what you need to show for a waiver. The only other point I will make is that Penn was 17 years old at the time of the killing, and at a minimum, he's entitled to an order striking the without parole portion of his life sentence. Unless there are any further points, I will leave questions. I'll leave the remaining points to the brief.
All right, thank you.
Thank you, Counsel. Thank you.
May it please the court, Kenneth Steinfeld for the Commonwealth. The Commonwealth takes a very, very different view of the evidence than the defendant in terms of showing...
Who knew?
Well, it's obvious, but it's true. There was an abundance of evidence that it was the defendant rather than Serrano who was the shooter, and as Justice Lank pointed out at the start of my brother's argument, the height differential was the most important evidence on that point. Benjamin Serrano was 5'5", and that's according to his booking, and that came through the trooper. Willie Guzman, the victim, was 5'6", and that came from his autopsy, and defense counsel stipulated that the defendant was 5'11", that is 5 inches taller than the victim. The trajectory of the bullet and the observations from Mr. Estrella make it very clear that the shooter is substantially taller than the victim. I disagree.
Meaning that the bullet came in a downward direction?
Directly downward. When the witness, Jose Estrella, made a demonstration of the motion that the shooter had taken, Judge Whitehead said, let the record reflect that the witness has taken his hand from the downward position up in an arc and then directly downward onto the top of the victim's head. He said directly downward, and there was no objection from defense counsel.
Now, a shorter person could do that too, though, right?
I don't know whether or not he could. It is a lot more likely that a taller person can do it, but the testimony from Mr. Estrella was clear, and I disagree with Mr. Curhan's characterization of the testimony from Mr. Estrella. He was adamant that there was no crouching at all. He said he stood tall, he did not crouch, and he did not say that there was a possibility that he did crouch. He was adamant on that point, but as Justice Lank also pointed out, the jury were entitled to believe him when he said, I didn't see him crouch. He stood tall when I was watching him. There's no evidence that he crouched at all during that.
And did the autopsy reflect the I mean, was it a corroborative of Estrella's testimony in terms of the direction of the bullet?
Yes, the bullet lodged in the base of his skull. The bullet never left his body. So I think a person who was an inch shorter than the victim might have been able to put the gun on his head, but whether he could do it straight down so that the bullet didn't even leave his body, it went straight down.
So the bullet was viewed as vertical, going straight down the skull towards the mouth? I mean, basically...
No, he said at the base of the skull is where it lodged, but it was in the rear left quadrant of his head, about an inch from the midline. And so that's in the back of his head, the rear quadrant, making it more likely that it's a taller person. Also, what has not been mentioned was that the gun was in the defendant's hands seconds before the shooting. It's true that Serrano brought the gun, but there's no witness other than the defendant who places the gun back in Serrano's hands after the scuffle has started. There was testimony that at the start of the engagement, both Serrano and the defendant had hoods on, had things covering their heads. But there was testimony from Johan that during the scuffle, Serrano's hoodie fell off. So there was evidence that at the time of the murder, Serrano's hoodie was not on. But it was clear there was no testimony that the defendant's hoodie ever came off.
I'm sorry, when you say the hoodie, the sweatshirt stayed on. You're just referring to the hood part of the sweatshirt.
Yes, that's right. During the scuffle, they both had them up when the encounter began. Hoodie, they both had them up when the scuffle started, but there was testimony that Serrano's came down during the scuffle. There's no testimony at all that the defendant's ever came off his head. And of course, he was described earlier by Vicky with a Y Gonzalez when he came to the door as being dressed all in black, and he had something covering the lower half of his face, and he had a hoodie on as if he was trying not to be able to be identified.
What did the testimony say as to where Serrano was when the victim made a run for it?
Where Serrano was when the victim? Well, he had just escaped from his clutches, so he was on Oxford Street near the intersection.
But was Serrano on the ground when that happened, or was Serrano on his feet? Do we know that?
Unclear. They were scuffling in a wrestling sort of motion rather than throwing punches. There's no testimony as to whether they were near the ground, on the ground. I don't think they were standing. They were scuffling, but there's no evidence that they were on the ground rolling. But at some point, while they're on Oxford Street, Willie broke away, and then either the defendant or Serrano chased after him. Moving on to the argument that the standard should be a reasonable juror instead of a rational juror, I agree with Chief Justice Gantz that there is no real distinction, but I think even more importantly, there's no legal basis for this court to draw one. Under federal constitutional law, Jackson is the law that says any rational trier of fact, and so this court cannot say that under federal constitutional law it has to be reasonable.
We could under our law.
Certainly, but there's no argument made below that the state constitution requires a different result, and in fact, the defendant acknowledges in his brief that under both Article 12 and the Due Process Clause of the Constitution, the question is whether any rational jury could find beyond a reasonable doubt. And Jackson itself basically uses the terms reasonable and rational interchangeably.
And don't we in some of our cases? I mean, I was just looking at, in Houseright, for example, we said the evidence was sufficient to permit a reasonable jury to conclude.
Yes, they are generally used synonymously, and I don't think that there's a real difference between them. And so, of course, you might say, well, then why not have it just be reasonable? And I think that the rational standard has become such a part of our law that there's no reason to change from it. There's got to be a good reason to change something that has been the law for so long. And I don't think that there's any problem here to be resolved. So I don't think that there's any state constitutional law basis to do it. There's no argument. The argument in my brother's brief about Article 12 is non-existent, and so under 16A4, there's not adequate appellate argument. He basically just asked the court to do it because he prefers that to be the law. He does not ask that this court exercise its superintendent's powers under 211 3. Of course, the court can do that, but I don't see any benefit to it or any reason to fix a problem that doesn't exist.
With regard to the good faith error in the ID instruction, do we view that as an error that's reviewed for prejudice or reviewed for substantial miscarriage?
It was waived twice, and I'd like to make this very clear. The first time was they had a discussion on day 3 of trial. The defendant had filed a motion that contained 5 requested instructions. The first 4 dealt with Rodriguez-like instructions, but they were more detailed than Rodriguez, but they were the same points made by Rodriguez. So the judge said, oh, this is a Rodriguez request, and defense counsel said, yes. And Judge Whitehead said that he was not going to give those instructions the expanded version of them. He said it was the expanded version that he thought would intrude on the jury's province, but that he would give the standard Rodriguez instruction. The fact that there was also a Presley instruction there at the end was never brought to his attention. He didn't discuss it, nobody discussed it, and frankly, I don't mean to be facile, but if the issue had been raised, Judge Whitehead would have allowed it because he was entitled to it. So he clearly did not know that this was in front of him at the time. But even if he did, at the start of the charge conference, Judge Whitehead said, I've been thinking about this, and I have come up with an instruction specific to the needs of this case, because this is an observation case rather than an identification case. And so he read to defense counsel and to the Commonwealth his proposed instruction, which incorporated Rodriguez with the facts of this case, a very well-tailored, very good application of the Rodriguez principles to this case. The defense counsel said, fine. He had no problem with it, didn't object to it. And also after the charge, he didn't object to it. So I don't think there's any question but that the standard of review for this claim is a substantial likelihood of a miscarriage of justice. You know, the mere fact that it's on the last page of the request for instructions is not enough. The defendant has to make some effort to bring it to the court's attention, and I think that the record makes plain here that that simply was not done.
So you're saying that to the extent that the objection was preserved, it was to Judge Whitehead's initial declination of giving the expanded Rodriguez instruction.
I'm sorry, I don't think that I agree with
Okay.
that, but I'm not sure. If you
There
could
was
please rephrase it.
apparently some objection that was lodged by defense counsel earlier on that Mr. Cohan has called our attention to in his reply brief, and says that...
he points to the discussion that I've just explained, where they do not discuss Presley.
And the objection was that Judge Whitehead at that point refused to give...
Right, but he didn't. I think that if you read the transcript, he never had the opportunity. There's no evidence that he knew that there was a request for a Presley instruction in front of him.
Oh, right.
In fact, defense counsel... I'm sorry, Justice Lane.
So after the judge indicated that he was inclined not to give the supplemental instruction, whatever it was, defense counsel acknowledged the court's ruling but asked the court to note his objection for the record, and the court said okay.
Right, but the objection that he made was, he said, in fact, I'm only asking for expanded Rodriguez. He says there's no other legal basis for what I'm asking for other than Rodriguez. So the objection that he preserved, that he waived later by failing to object when the charge was given, when the tailored instruction was offered, but the only objection that he preferred was the variation between Rodriguez and his expanded Rodriguez. He never preserved or made an objection to the judge's ruling on the Presley issue because there was no Presley issue before the judge. It was merely on the last page. And I think...
Saying that the judge overlooked the Presley instruction and it was just never brought to his attention, and so he never actually made a ruling on it?
I'm not saying that he overlooked it. I'm saying that defense counsel never brought it to his attention, and it was defense counsel's obligation.
But it was in writing before him as a part of his request.
Yes, that's true. And the judge looked at it, and he said, this is just for Rodriguez purposes, and defense counsel said, yes. And they just talked about Rodriguez. So he looked at it, and I imagine that he flipped through it, did not see that the last page was a Presley instruction, but at that point, the judge has come out, and he's characterized the request. And he says, I perceive that there's a request for amplified Rodriguez. And the defense counsel did not then say, not just that, Your Honor, we're also seeking Presley. Never did that. So I don't think the judge had an obligation to read every page when he's told defense counsel what he perceives to be before him, and defense counsel agrees that that is the limit of what is before him.
Was there in the cross of Mr. Estrella any challenge to his honesty as opposed to the reliability of his observation?
None. He was considered, I think, by defense counsel and by the Commonwealth, and I think by the jury, as a solid citizen doing his best. The defense counsel did say in closing that he was perhaps stuck in his ways, thereby implying that he was clinging to a belief, but there was never any implication that he was a liar. The challenge to his testimony was based on the conditions of the observations, the distance, the rain, the dark, and most importantly to the defense counsel, the things he didn't see that the defendant says he should have seen or would have seen if he had in fact been looking, and if his ability to perceive at a distance had been as good as he said it was. So no, there was no suggestion at trial that he was lying by anyone.
All right, closing argument. I know it was not raised except in the brief. That is the truth by the prosecutor.
Yeah.
That he aired, he said Estrella told the truth, that the defendant was the trigger man. That is the truth. Perhaps not the best moment of that prosecutor's closing, I would think.
No, but certainly not a substantial likelihood of a miscarriage of justice when you consider the closing in its entirety, which I think is an outstanding example of forceful prosecutorial marshaling of the evidence. And I think it was clear from the context that the jury would have understood this, that they should find the defendant guilty based on the evidence. I think it's similar to the Polk case, where this court held that that kind of or that a problem in a closing argument at the end of a closing argument could only be reasonably be meant to say, based on the evidence, the overwhelming evidence, it is the truth that the defendant killed him. Not the best way to put it, but I don't think anything close to a substantial likelihood of a miscarriage of justice. And here, there's no claim that that error was preserved at all. It is undisputed that there was no objection made to it.
Okay, now I think I have the right case now. He was 17.
He was 17.
And you're saying it should be sent back to, I guess it can't be the same judge since he's retired?
Unfortunately, it's a great loss to us up in Essex County, but yes.
So it has to go to a different judge for resentencing?
Yes.
And
is resentencing the right term?
Well, that's the term that's used in the Ray case that I cite. I believe there's a quotation from it.
I think it's on page 29 of your brief.
Yes, the same relief that was granted there is appropriate here, page 29.
Maybe not. No?
No.
Maybe it's... I know you cited...
Yes, page 39. You're very, very close, Your Honor. The proper remedy is,
pages.
quote, remand of this case to the Superior Court for resentencing consistent with Diachenko 1.
Now, does that mean...
End quote. That's from Commonwealth versus Ray. And my defendant, or I'm sorry, this defendant falls within that category, the same as the Ray defendant.
He was also convicted of a firearms violation.
Yes, he was.
And would the resentencing include that, or would it only be the murder?
He does not challenge the conviction, but I'd say that as an integrated package, ordinarily the judge would have the discretion to resentence on that. I don't think he would, but I think he has the authority to do so. I do not recommend that this court send it back for that purpose. I think it should, just like in the Ray case, be sent back for resentencing on that.
I'm sorry, on that, meaning resentencing only as to the murder?
Yes.
So you would say that the judge would not be able to say this is now a new package?
Oh, no, I'm saying he could. I think he has the discretion to do it. But I don't think he would exercise. Well, I think
We don't know who the judge is going to be.
So. No, I don't. But I think that under these circumstances, he or she is unlikely to reconsider, the sentence imposed for that fairly minor violation when compared.
But apart from predicting what would happen, your view is that our order should be that the sentencing as to all convictions goes back for resentencing.
I don't have a problem with the court saying for resentencing on the murder conviction and for the firearm conviction if the trial court believes that it's appropriate. So yes, is the short answer to that
But
question.
doesn't Diachenko simply strike the proviso that the life sentence will be without parole?
Yes, but I think as a general matter, sentences in Massachusetts are considered as a package, and I know that of course with murder it's a life sentence, but there is some discretion that the judge has with other sentences,
So
you
the
know,
judge
whether they're
could-
minor or not.
So that what you're saying is the judge could say, okay, well, it's going to be life with the possibility of parole under Diachenko, and by the way, I'm also going to now sentence him to from and after time on the other offenses, that wouldn't be problematic.
That of course would be problematic.
Okay, well, I'm trying to figure out what.
Yeah, I didn't. It didn't even occur to me that he would do such a thing. It seems that the time here runs concurrently, and I think that that's appropriate. That's what Judge Whitehead thought was appropriate, and I think that a subsequent judge, of course, I can't predict what a subsequent judge would do, but it seems more likely than that, and that would appear to be possibly vindictive sentencing afterwards. So I think that it's unlikely. Lastly, if the court has no further questions, the defendant asked that this court dismiss the indictment, and I am not aware of any authority that provides it with that power. 33E does not. If the members of the panel have no further questions, I will rest on my brief for the remainder of the arguments.
Thank you, counsel.
Thank you.
All rise.